Brian Tarian from the Veterans Disability Digest. In this quick video, I'm going to give you an overview of the legal documents that you need to authorize in order to retain a veterans disability attorney. The effort here is to try to take some of the confusion and mumbo-jumbo out of the legal documents. So this is a standard fee agreement, and you may receive one that has slightly different language, but for the most part they're going to have some key ingredients in it, which is the attorney's name, address at the top, and they're going to be referred to as the attorney throughout the agreement. The first section will generally have information where they want to have you indicate the source of the decision that you received. And again, typically attorneys get involved after you've received a favor or unfavorable decision, or as some call it, have been denied. So where did that decision come from, the date of it, and are you renewing the claim, a motion to consider, or appeal? If you don't understand what that is, then your veterans disability attorney can help you. Issues is simply a statement as to what happened. Perhaps you get a 10% rating, you felt it should have been 50, and explain why, what your issues are in a brief statement there. Some of the other key things are, the fee structure is a contingency fee agreement, meaning that the attorney only gets paid if they win, and it's set by the VA. So you'll see language that says 20% of the gross amount of any benefits recovered. So if they recover $20,000 worth of benefits for you, then they will receive 20% of that $20,000, for example. Typically it's much higher than that. But that's an example. Nothing with your check going forward, just the percentage of the back benefits. Some other key things are expenses related to representation. You might see clauses in here. Typically there are very few, if any, extra expenses or out-of-pocket expenses that you are responsible for. Sometimes you'll see language where it's anything over $50 and out-of-pocket expenses you'll be advised of. Anything less than that, they're just going to accumulate and bill for you. So just have a look out for that terminology in there. Let's see here. Client, also the attorney can designate outside professionals. Sometimes you need a professional medical advice or diagnosis, and so there can also be language in there. It's usually pretty straightforward. I'm not going to, there's no set standard for it, so I'm not going to get into detail about it. You can withdraw or release your attorney. There should be language in there relative to that explains, what happens if you release your attorney and want to hire another one. And that you need to be responsible for advising your attorney, which is key, communication, of anything that you receive from the VA. So those are some of the key components of it. This document that you typically sign will replace any prior document or power of attorney that you may have had, maybe a service officer. Okay, so just be aware of that. And then you want to sign on the bottom where it says date and Social Security number and date and your signature there. So another document that you're going to be responsible for is Form 2122A, and this appoints the representative to represent your case in the eyes of the VA. So you'll see here a name of claimant. Of course, claimant is you, last name, first name, service numbers, what branch you were in, and who your attorney is that's going to be representing you. Are they an attorney or are they an agent that's going to be representing you? Signature of representative, signature of claimant, that makes it all official, and of course the address. So there's other information down here that gives the attorney the ability to get all your medical records. Of course that's important so they can build evidence to get your case proven, and that's typically it. That's what's in here. So let's go forward, make sure you get all that completed accurately. There might be some other information that some will send to you, which would be a statement in support of claim, which is really in your words, why you are either filing a claim or why you are appealing your claim. And it should be in your own words, but typically you can get guidance and the right verbiage so that you can wordsmith this in language that's friendly from the VA, so your representation should help you out with that. So that's it. Pretty straightforward and simple. Hopefully this has been helpful. This has been Brian Therrien from the Veterans Disability Digest. Thank you.